May 4th, right? 2022.
What?
Tomorrow is Cinco de Mayo.
Oh my God.
Those of you who keep track of those things. This is Senate Judiciary. Our first item on the agenda is House changes to S-224, which was the bill seeking to make amendments to the juvenile proceedings law that we passed a couple of years in 2018 that basically is known as raise the age. So Eric, if you would be able to go over that, and we have excuse me, Commissioner Brown of the Department of Children and Families, and Jennifer Micah from the department, also the General Counsel for the Department of Children and Families with us. And I don't know who wants to go first. Eric, do you want to kind of go over the changes, or should we hear from the Commissioner and the General Counsel?
Either way, I actually went over the changes aren't any different from what I went over a couple of days ago so far, and it's actually the bill has been delayed a bit, but it's on the Senate. I think it's actually on notice today, and it's not actually up for second reading until tomorrow. So there aren't any amendments on the calendar at this point, so I'm not aware of any. But I can run through the changes again, Senator Sears, but it's no different than what I mentioned earlier.
Senator Sears.
Yep.
Did you got the note from Jay Johnson about the fluffle around this and 175? Yep. Okay.
Yeah. At the time when she wrote that email, there were still questions about the report section, and that there were some concerns from the Department of Children and Families on the report, and they wanted to work it out with DCF, and so that was basically where I left it. Then this morning at 4:40 a.m., I didn't get up at 4:40 to read the email, but I got an email from Mike Donahue that the Vermont Press Association is concerned about the availability of information, but I still think that they are, that the information is out there when a kid commits a serious crime and it's taken up to adult court by the judiciary. So that information would become adult if it's a serious crime, and in the interest of justice, as I read the bill, and Eric, you can correct me, then that becomes a public information.
It's in the criminal court, in the adult court.
Yeah.
Yeah, did you say in the criminal division in the adult court?
Mm-hmm.
Yeah, that's right. Yep.
So they're concerned that they wouldn't know who the person is who committed the crime, or who's alleged to have committed the crime, would be available if the state's attorney or the court decides to move it to the criminal division. Is that correct? I think I froze. Love technology.
No, we got you. We got you.
Oh, okay.
Yeah.
Maybe it's Senator Baruth that's frozen.
No, I'm not frozen.
Oh.
Actually, it's Senator Benning.
I was reading the bill.
Oh, it was an interesting occurrence yesterday on the floor when everything froze for those that were away, and Senator Bray's mouth was wide open. It was like you could just think about what Charlie Brown might have been saying at the time. Commissioner, are you on the line?
Yes, good morning. How are you?
Good.
Good.
Nice to see you this morning.
Good to see everyone. And I'd like to wish the best to Senator White. It's been a pleasure working and serving with her, and I wish her the best in what comes next for you. And I'd also like to thank the committee and you, Senator Sears. I mean, we started work on S-224 last fall, in some special committee hearings to get this bill moving. So when the legislature convened in January, it was ready to move forward pretty quickly, and we really appreciate the committee's attention to this bill and work on this bill. We did work in the House with on particularly regarding the language regarding I think 17 and 18 regarding some reports. We worked with Corrections and Institutions, House Human Services, and House Judiciary. We're comfortable with the bill the way it is currently configured, and we support it, and we're looking forward to its passage and the work contemplated in the bill and the changes contemplated. That work continues behind the scenes now, and so we'll be prepared to meet those timelines that are in the bill now for the different reports that we're required to submit. And so unless there's any questions, I think we're comfortable where it is right now and don't have any additional feedback or requests for changes from the committee.
Thank you.
3.1.
Yes.
Senator Nick, did you have a question?
I just want to confirm that what you're comfortable with is version 3.1. Commissioner Brown, Jennifer, that's the one you're comfortable with, that one?
Yes, that's the version I was looking at and reviewing this morning. We are comfortable with that version.
Right.
Thanks.
And I just defer to our general counsel if she has anything she'd like to add.
I don't have anything. If you have questions about anything that's in there, I can walk you through the changes if you'd like. But we've worked very closely with the House committees on this, and I know they expanded it, and we're comfortable with the expansion, and we're comfortable bringing you in December our plan for how we're going to house and treat young people in the justice system. I spoke about it in the JJ stakeholders group yesterday morning as well, noting that we were going to be looking for that group to weigh in and help us out, thinking about how to put up programs and provide treatment for these young people. So we've already gotten started.
Good. Is there anything that would prevent this report from being shared with the Justice Oversight Committee without naming the Justice Oversight Committee?
No, we're happy.
It'll be a public document.
Yeah, it'll be a public, and we're happy to share it.
Okay, I'm concerned that Justice Oversight should be looking at the report, and whether or not you want to put a little line in there, Eric.
Well, they're going to get the preliminary report in July.
Yeah.
So they're already in there for that.
Oh, okay.
Yeah, July 1, we have to provide a preliminary report.
Okay, good. That's good. We put that in, didn't we? Or
Yes, you did, Senator Sears.
okay, it didn't get taken out. Thank you.
Yep.
Just reading it. All right. I think we should just concur with the House.
Sounds good to me.
Good to me.
Is that okay with everybody?
Yeah, I was waiting to see if you had another comment to add to that, Dick. I don't hear those words often.
Well, my only comment was I was surprised at the number of House committees that had to get involved in the report section. I remember going upstairs, since you asked, Senator Benning, I remember going upstairs and talking with Representative Graydon Emmons and scratching my head at how it got into Human Services Committee and all of that, but I guess that's how they operate. All
I
right.
do want to say how much I appreciate Senator Sears, you moving this bill and listening to us and the other parties on this. I think it really was an effort by a lot of different people, and I think that without you, it would have been much more difficult. So I want to say thank you for that.
Well, if I look back on it and if I don't run again, this would be one of my legacies, that we reformed the juvenile justice system with all its warts and all, but we have a fairly good system that does help to change lives. And through the pandemic, it's been a difficult time, and but I appreciate your comments, Jennifer. All right. Well, I guess we'll just concur.
Okay, we have to vote on that. No,
We should vote.
We just,
we should vote.
oh, okay.
So said Senator Sears, we couldn't hear you.
I think we should vote.
Okay.
And it should the Senate concur with the House proposal of further amendment to S-224. Peggy, could you please call the roll?
Senator Benning,
Yes.
Senator Nika,
Yes.
Senator White. Yes. Senator Ruth,
Yes.
Senator Spears.
Yes. I wasn't sure who that Baruth guy was.
I was waiting for her to use the preferred pronunciation, but
I was going to.
Thank you all very much. That takes us to the next agenda item, which is, and it's, I think it's ironic, all the talk about the United States Supreme Court in the last 24 hours, that we're voting to confirm or not confirm a judge appointed by Governor Scott through the Vermont Judiciary. Daniel Richardson.
he won't be here for a little bit though, right?
Actually, I don't think he's coming. He met with us yesterday.
Oh,
And we
okay.
wanted to hold the vote until you were available because you were in conference yesterday.
Yep. And I know him through other channels, and I think highly of him.
And he was, I was impressed with his answers to some of the more difficult questions regarding his views regarding the qualified immunity bill, and he talked about it more as opposition, more on the level of as a city attorney and unintended consequences that might come with decisions made. So is there a motion to report favorably the confirmation of Daniel Richardson as a Superior Court judge?
I make a motion.
Senator Nitka has moved that we report favorably on the appointment by Governor Scott of Daniel Richardson of, I believe he's from Burlington, correct?
He is.
To the Vermont Superior Court. Is there any further discussion? Peggy, could you please call the roll?
Senator Benning,
Yes.
Senator Nika,
Yes.
Senator White. Yes. Senator Ruth.
Yes.
Senator Spears.
Yes. I shouldn't have coffee when you did that. I may have to change my shirt now. Senator Baruth, would you like to report him on his confirmation?
I feel like since I missed his
Yeah,
hearing, it wouldn't be the best.
okay.
But I will do it if you really need me to.
And I would actually, Senator Benning, would you like to do it?
I was kind of trying to avoid having to do any more reports because I just found out that our capital bill is in jeopardy.
I'll do it, Dick.
Okay.
We can give you some of the things that he said, or you can actually watch it.
Yeah, I mean, people don't usually report too much from that hearing. They talk about his career, so I'll do that.
Okay, thank you.
Yep.
And he gave an interesting response to a question that Dick asked him. I mean, it was very, very thoughtful, good response, not the usual questions, you know. So it might be interesting for you to hear it.
He
Okay.
also didn't push back on our decision to remove that new language in the restrictive covenant bill. We took out that piece that he was kind of
Yeah.
advocating for.
Yeah, he's just, I think, a very thoughtful person.
Senator Burris, I'll give this to Senator Benning to bring it up to the Senate Secretary, but I'll make a note that you're the reporter.
Thank you, Peggy.
Are you, are either of you, you're not coming to the floor today, right? Neither of you will be there
Just virtually.
virtually.
I'll
Okay,
be there tomorrow in person.
Okay.
Yeah, I will be there tomorrow.
okay.
Are you looking literally at the back of my head when you're on the screen?
Yes,
I'm not.
No, where do you?
No, when we're on the floor and you guys are zooming in.
Oh, yes, then we are.
at you and Senator Kitchell mainly.
You didn't notice, Joe, you didn't notice that Philip put sunglasses on
No,
for the reflection?
no, it wouldn't surprise me, but I didn't notice.
It is.
Actually-
I will say though, the ability to hear people's conversations is amazing. Like, especially for some reason, Chris Pearson, I can hear everything he says on the floor, no matter who he's talking to.
Is that right?
That's because the microphone is right in front of him,
Yeah,
that box.
And,
But
and also in front of Mark McDonald.
easy to forget.
Yeah, that was an interesting. When you all froze, that was. I hope it doesn't happen today, but
It was pretty funny. And you know what, one of the things that we heard, why that was happening?
why?
Was because there was so much interference, because it was done on not hardwired, and because tons of people had their phones on their desks and didn't have them turned off. They just had them on airplane or silent, and it was still using bandwidth when they're not turned completely off. And so many people had their phones laying there just on silent, that it was using bandwidth.
I had no idea.
Yeah, it was overload, and so their decision was should the LG announce it and ask people to turn off their phones, but by the time we came back, they had it hardwired. They were back there working on it the entire time we were on the floor.
That was, but it's hard to see some of the people, like Senator Cummings, Perchlik, and Polina. You don't see it all
Oh, really? Huh?
Oh, because they're over there.
because they're over there on the, and then on the my left, you can't see Collmore.
Right.
It was very disconcerting giving that restrictive covenant presentation yesterday, knowing you guys were behind me.
Well, I was watching carefully.
Well, Joe, I have to say,
We're like this.
I had a small bout of depression when you started with the Mayflower,
Oh, my God.
because I was like, oh no, 2 hours.
Heard about the Mayflower this past week. We heard about Abraham Lincoln. I don't know. I think maybe I'll talk about George Washington.
And Allison was going off yesterday about
The Queen.
yeah.
Oh my God.
There were a whole bunch of kind of irrelevant.
Very irrelevant.
Yeah.
Well, I thought her speech was king of a little bit of information, because she never mentioned it was also Humperdinck, Engelbert Humperdinck's birthday is the same as Senator White's. And I thought that I was a missed opportunity.
Yeah. Well, I'm gonna refer to it over the Hunt.
Both are show people. If you've noted that Senator White's performance frequently, back when we used to have that end of the session show put on by the House and Senate. What would we call that?
Cabaret.
Capitol Cabaret, right. Back when we had the cabaret, White was one of the star performers, and Humperdinck certainly was a star performer as well. So I thought that was Senator Clarkson.
That's a good connection.
Yeah, not connecting the show people and only
Me and
queens.
Who's the reporter on 224?
I am.
You are, okay.
Senator Sears, I just wanted to let you all know that the one other bill that's coming over from the House that's gonna have some changes is that courthouse arrest bill.
Oh,
Okay.
what's
So
happening
that's
there?
also, pardon me?
What's happening with that, Eric?
I think that I'd say the two main changes are, and one of which I think was being contemplated in this committee, if I remember correctly. You remember that the protection only applied to the person who was going to the proceeding or coming from it or there, or a family member.
Yeah.
And so then there was discussion, I remember in this committee, so whether shouldn't it just apply to anybody who's going into, or anybody who's going to a courthouse proceeding or coming back from it. You know, so that way it would cover anybody, say, who's a party or a witness, or somebody who's giving a ride to the party or the witness. So they did that. They just applied to any person who's either at the proceeding or on the way to it or going home from it. So that's change number one. The second one is really, it's a funny one that, believe it or not, there's an existing statute that does this already, that no one knew about. Judge Zone noticed it at the end of last week. It's been on, some form of it has been on the books since 1797.
wow.
So, yeah, so Michael Chernick did some research on it. But the statute itself is also, it covers something. There's even a piece of the statute that covers legislators and the governor. They can't be arrested when you're on the way to the legislature or back. That's
Yeah.
it's in that same statute.
It's in that
Oh,
same section.
Yes. But again, it only applies to parties to the proceeding. So it's just a technical thing, but so rather than create a whole new statute, this new piece that you guys were talking about was just added to that statute.
Oh,
So, yeah, it made more sense once we knew about it.
yeah.
Funny, all those people who worked on it, nobody knew about this statute.
Well, I knew about the legislator thing.
Yeah, we all know about that one.
Right. Right,
Be
because
you can
them
be
cops
stopped.
Can't arrest us on the way.
Well, you can be stopped, but you can't be
Hear that,
detained.
Roger?
It's my understanding of the bill, of the law.
Yeah,
They can't detain
you
you.
can't, yeah, they can stop you if you're speeding or recklessly driving, but they can't detain you.
Right.
Important mistake.
Well, the reason is
Yeah.
you might be voting on
Yeah.
something to do with them, and the ability to detain you would keep you from the vote.
Yeah,
Or if a governor, wanted to play super hardball,
Yep.
and there was a vote where one vote would make the difference.
Yeah.
I mean, I hate to say it, but it's starting to look that way in Florida.
Yeah.
Right.
Is Ben in the room?
Ben is here and it looks like a lot of the witnesses are here. I don't know if you want, I need to make a phone call, so I'll do it either after or before.
Why don't we take a brief break? And I mean brief, like 5 minutes.
This will take me 5 minutes.
I'll log on, so.
Okay.
Good. A brief break, and Peggy, you don't have to go offline. Just people who don't want to be seen, just take off their mute.
Morning.
Are we ready to get back?
Yeah, I sent it to
Okay, we're back.
him.
Eric, is this yours?
I worked it out last night, so I can go. I hope
Eric,
so.
is this your, excuse me a second, is this for Senator Sears?
No, that's mine. Thank you very much, Evan.
That's not-
Eric, would you prepare me a little blurb on 224? Eric?
Yeah. So you mean concur?
Just a little bit of information changes they made.
Yeah, sure. Will
That would be
do.
helpful.
Yeah, no problem. I'll email it to you.
Okay, thank you.
You bet. All right. Good luck, everybody. See ya.
Thank you.
Yeah,
Hey, Eric.
All right.
you bet.
I don't know if that's gonna work. I don't know if tomorrow it's gonna work out. Sticks. Well, we need to know if Senator Sears is staying all night.
All right, we have,
Jeanette's not back yet.
why don't we start though? We have draft 3.1 of the civil forfeiture bill. And I think we've been through it, haven't we?
We
Yeah.
did go through it, and there was some I don't know if confusion's the right word, but people on the committee felt like they didn't know where they were, if
Right.
I remember the phrasing.
Yeah, I think the question really is, do we go forward with the bill? That's question number one.
Senator Sears, do you want me to share my screen and put it up online?
We've already been through the changes, haven't we?
Yeah, there were two small changes on page 5 about prohibiting the forfeiture proceeding if notice was not originally sent, basically explicitly prohibiting that second bite of the apple, so to speak. And then on page 12, lines 9 through 13, the innocent owner burden, just basically to clarify that you wouldn't need to be to prove a negative, and the owner wouldn't have to rat out another. So what it does is that the owner proves their ownership interest in regular use. The burden shifts to the state to prove that the owner did consent or have knowledge of the use that would subject the property to forfeiture. So there were those two clarifications, and the draft had been circulated to all the stakeholders on Friday, and there was no input, one way or the other before today.
Okay. All right. Let me go back to my agenda. Evan Meenan, Department of State's Attorneys.
Good morning, everyone. Thank you very much for inviting the department to come and offer comments on the latest draft of 533. For the record, my name is Evan Meenan, and I work for the Department of State's Attorneys and Sheriffs. I anticipate that my testimony is going to be incredibly brief, absent any questions, which I'll do my best to answer. There have been several drafts of this bill to digest over the past several days and weeks. And the department is very grateful that we've had an opportunity to offer comments on each draft. It does feel as though those comments have been heard, and many of them, but not necessarily all of them, have been incorporated into the draft. Legislative Council on this bill did a lot of work over the past several days, and I really appreciate the outreach that has been given to all of the stakeholders. I think that those efforts really are the cause for having a draft that's in as good a shape as it is right now. One of the issues, I think, with any bill that is passed out of the legislature regarding state forfeitures is has been discussed, the existing state law really has not been used very widely. So in a sense, we're trying to come up with a system brand new in the first instance, which means we're really not going to have a very strong sense of whether or not this is going to work until we start using it. We're optimistic that we can function under this bill. But obviously, if we encounter any problems, we'll just have to bring them to the legislature's attention and hope that we can come up with some sort of workable solution. As I've previously testified, the department really isn't involved in federal forfeitures or what's, federally adopted forfeitures. So we're really deferring to the Vermont State Police and the Sheriff's Association to identify concerns with those sections of the bill. And I can't say that I disagree with the sentiments of Senators White and Baruth that since there has been so much work on this bill, and since it looks so much different in some respects than what the House passed in a short amount of time, we would understand if it's not possible to wrap up this work this session, and if the legislature decides to take up this topic again next year, obviously the department will do its very best to help the legislature in any way we can. So basically, we'll do our best to help implement this bill if it's passed, but we really do appreciate the fact that a lot of big changes have been made recently.
Thank you. Yeah, I do. Ben has worked tirelessly on this issue. Seems like he's gotten some of the thorniest issues this year, including qualified immunity, criminal threatening, which I see the governor did. The governor did sign the criminal threatening bill, by the way. So next is Marshall Paul, Deputy Defender General.
Thank you. Good morning to the committee. I'll echo some of Attorney Meenan's sentiments. I think that there has been a real lot of work done on this bill since it came over from the House. But from our perspective, it still has not addressed our most significant concerns. And frankly, I'm not sure there is a way to address them alongside everyone else's concerns. And that's because, just to highlight sort of, I think the biggest issue that we have is on page 17, and that's the distribution. The bill as it came over, or the law as we originally had it, had 45% of proceeds from forfeiture being distributed among the offices that did the forfeiture, that conducted the forfeiture, and that's been raised up to 70% in this bill. The last version had it at 80%, and our office said that was too high. That 80% was really essentially creating an incentive for law enforcement to conduct law enforcement operations for the purposes of committing forfeitures or of effecting forfeitures. And that's something we don't want to see. That's what we see in other states. That's the abuses that we've seen in other jurisdictions that have really prompted this bill. It's those types of concerns that our office agrees really requires our state to take a close look at its forfeiture laws and to address those. It's just that the way that we see this draft, it's not actually addressing that issue. In fact, if anything, it's perpetuating that issue by creating a greater incentive for forfeiture. We don't see there being any justification for raising the percentage above what it is in existing law, which is 45%. Frankly, I don't quite understand why this is the means of compensating police for forfeitures in the first place. We don't seem to do this in pretty much any other area of law. We don't say that, a part of government that's job is to collect something gets to take a portion of those proceeds. Like we don't say to the tax department, you get to collect, 10% of the taxes you bring in. We just pay the tax department out of the general fund for doing the job of collecting the taxes. And, I don't understand from the outset, when we expect law enforcement to seize forfeitable goods, to seize things that people either should not own because it's contraband or have owned for the purpose of committing of using it to commit a crime, it's just sort of this, it's kind of baffling why it's just, I think an archaic, it's just a tradition that we pay law enforcement a portion of those proceeds rather than just simply saying that this is like the rest of law enforcement duties and paying them to do it out of the general fund. So it's already a bizarre system. And from my perspective, increasing that percentage at all just frankly perpetuates that system and increases the danger that we will see the same problems that they've seen in other jurisdictions where everyone's acknowledged that the cause of those problems, the cause of the forfeiture abuses, is because law enforcement is incentivized to essentially to abuse those laws because law enforcement in those states are underfunded and have access to massive amounts of funding through very high percentages paid on their forfeitures. So just at a basic level, we still have a fundamental disagreement here. And the compromise that was put into this version to lower the percentage from 80% down to 70%, we don't see as a compromise at all. We see that as just another version of the same thing, which is keeping that reimbursement percentage so high that it really is simply putting our state, aligning our state closer to those states that have seen real abuses of their forfeiture systems.
Thank you. Any questions from Marshall? Senator Baruth.
Not a question, but a point of agreement with Marshall. I have always, ever since I heard about the civil forfeiture, criminal forfeiture system, I've had the feeling that anybody who thinks that this wouldn't result in abuse is just ignorant of human nature. Because if you have the ability to seize homes, cars, other things, sell them, and then keep the most of the money, it just seems like you develop an entrepreneurial side of your law enforcement agency that seeks to increase this to the extent possible. And, I have to say the part of this bill that always made me the most uncomfortable was that percentage. And I think, for all the work we've done on all of it, I'm guessing, but most stakeholders would agree that that number is the single most important part of the bill because it's the one that will make our state version of this more attractive. So I'm with the Defender General's office in terms of my general aversion to that part of the bill. And I don't see that we pass it without raising that, which would be uncomfortable for me.
Okay.
Who wanted it? Can I just ask a question?
Yeah.
Who, for Ben, who wanted it at 70?
Me.
So
You?
Yeah,
Okay, there's that.
I think he wanted it at 80.
You wanted it at 80?
It was at 80 and I said to Ben, drop it to 70 and see what people think.
The bill though came in with it, was
At
introduced
45.
at 80.
No, the bill came in at 45.
Oh, okay. I see. Well, if it was at 45, would people be comfortable with the bill? If it was at 45, would people be comfortable with the bill?
Well, current law is 45.
And Alice, I think that's, I'm guessing because I haven't been in any of these stakeholder meetings, but I'm guessing that if you went with 45, people would say, well, there's not going to be a change from the status quo really, because it's not quote unquote attractive to the state authorities to use.
So can I continue? So when someone gets cash from, they pick up somebody at a house and they get, say, $10,000 in cash, what actually happens with that cash now? Where does it go if it all stays intact?
4,500 goes to the police agency. 5,500 goes to the state general fund.
I see. Okay.
Under current law.
Yeah.
If I'm wrong, correct me.
Is that true?
well, yeah, that's more or less, that's what happens after costs of selling the property, and so those expenses are paid out first. And then the change in this bill would also first pay restitution to victim of an underlying crime. So that's been added. So once it filters through those expenses that kind of take from the top, the remaining portions would be split 70 and 30.
Okay,
Under
Good.
this.
Under
That was
this.
a new one.
Yeah, currently though, it's just those to offset costs of selling the property, pay off liens, apply payment for seizure, storage, maintenance of the property. Then the remaining amounts would be distributed 45% and 55%.
We can focus on the amount and percentages. But are there other parts of the bill that you have a problem with, Marshall?
I think we also very much supported the original version of the limitation on federal adoption. This one, the amount of the limitation has been decreased to 5,000. The original version, I would have to pull back up to make sure that I get the number right, but it was substantially higher. And from our perspective, again, the purpose of this bill is to say Vermont law enforcement should be conducting Vermont seizures and forfeitures. And from our perspective, where we reduce that limit on federal adoption to the point where most forfeitures can just simply go federal, I'm not sure what we're really doing with the bill at that point. At that point, what we're really doing, because we're saying, where we say we're going to create this sort of much more usable, much more usable state forfeiture system, but we're also not going to substantially limit the use of the federal forfeiture system. Then rather than a bill that was supposed to kind of narrow the scope of forfeitures, we're really broadening the scope of forfeitures, creating, another tool in addition to existing tools to effectuate a forfeiture, rather than sort of narrowing the use of existing tools, which I think was the original intent of the original intent of the legislation, was to create a state mechanism and then to funnel a lot of the forfeitures that are, to funnel the forfeitures that are currently going federal into that state mechanism. And really what I think this version does is creates a state mechanism that's fairly powerful and also doesn't really limit the use of the federal mechanism to any significant degree, because for the most part, all the forfeitures that people, do are over $5,000. And so really this just creates a second tool and therefore kind of broadening the scope. So we have that concern as well.
Okay, thank you. Tucker Jones from DPS. Tucker, are you with us?
I am, Mr. Chair. Good morning. Good morning, Senators. My name is Tucker Jones. I'm Assistant General Counsel at the Department of Public Safety. Well, I'll just start by echoing Evan Meenan's comments about the collaboration here to try to come up with a state scheme that would be usable. There's been lots of work over the past few weeks to hone the process at the state level to come up with something that will work. And I appreciate being part of that. Ben has worked tirelessly on this, and to your point, Senator Sears, on lots of legislation this session that's been quite difficult and challenging to work through. For this bill, the state police don't oppose getting a state scheme off the ground, and they're willing to run some test cases through it. Right now, the state police and Vermont law enforcement largely use the federal system, and they've been using it for years, and they've been using it without incident. And right now in the federal system, there is the 80-20 split. So in my conversations with legislative counsel about crafting something on the state level, my recommendations were to, in large part, build something that creates a kind of comparable alternative to the federal system. And the reason for that was because from the law enforcement perspective, the federal system has been working quite well for them in Vermont. And we haven't had issues with it or misuse of it that we're aware of. And so we didn't have a broken system that needed fixing from the state police perspective. So that was kind of the approach that we were coming at redrafting this. And that's why, I recommended using the same distribution percentages as the federal system, because that it would create an alternative that would be just as good as the federal system for law enforcement, and it would provide the mechanisms for innocent owners at the state level with Vermont legislative control over the, how that's going to look. And that would be a reasonable alternative for law enforcement to use. But as Evan Meenan pointed out, this system isn't off the ground yet, and it's a relatively complex proposal. And so at this stage, the state police wouldn't support limiting the use of the federal system unless we really had at least a viable alternative up and running. And that, that's the law enforcement perspective on this. And it really comes down to this idea that we've already been using an 80-20 system for years. And in Vermont, we haven't had a problem with it. And so as it relates to the concern over the incentive for misuse, I understand that that's a concern that has come up in other states. But it seems like it hasn't been an issue in Vermont. So that's the perspective of the state police. Again, really appreciative of the collaborative work from Legislative Council and willing to help get a state system off the ground. But we haven't seen an issue with the federal system from the law enforcement perspective that would require limiting its use. And if anything, from the law enforcement perspective today, we want to preserve the tools available to interdict the drug trade in Vermont and whatever those are. And we wouldn't want to be in a position of limiting what's available for Vermont law enforcement to do that. So that's the extent of my kind of broader comments.
We can't lose sight of the fact that drug distribution is a business, illegal business, that's carried on in Vermont because we have willing buyers. Obviously, we have to do everything we can to prevent use of illicit drugs, do our best to control that. But the reason that these people are selling the drugs is because it's a profitable adventure, and they're able to make huge profits. And this is, in my mind, a way to get at some of those profits. And so that's basically why we do forfeiture. Many of the amounts that we see are small amounts, and $2,000, something like that. But we also see much larger amounts in many of these cases. I just think we have to remind ourselves of what it is. This is a business venture. The fact is, we heightened overdose and so forth. We all know we can't arrest our way out of this problem. That we have to work on the demand side, but this is working on the other side of it. Those that are profiting from the illicit drug trade. Roger Marcoux, do you have any comments before the committee tries to make decisions here?
Yes, good morning, committee. My name is Roger Marcoux, representing Vermont Sheriff's Association. And Senator Sears, I think you and the previous witnesses have brought up many of the thoughts I was going to bring out. But I will say that anything right now that takes law enforcement ability away from working on this very, very significant problem in the state that has been overshadowed by COVID, but just by the overdoses alone, we're in a crisis situation more than we've ever been. Anything that takes away from our ability to be able to investigate and counter that, just puts us further and further behind the 8 ball. I have a suggestion. If this was not to pass today, I think that some of the questions that should be looked at is relative to how significant is
Breaking up.
Vermont. What did those agencies spend the money on, and how many extra cases, or how many cases, if we were to do other than that, would that put onto the state court system that is already, a couple months ago, there were 15,000 cases behind. So if the committee were to go in that direction and to take a look at all of this, it might answer a lot of questions and not maybe come up with legislation that would have to be readdressed later on with unintended consequences or what have you. The other piece that I just want to bring up is my confusion in the forfeiture. And I really wanted to thank Ben for reaching out for all of us, and me particularly. He really took time to listen to what I had to say and everything, and I really appreciated that. My confusion is in the federal forfeiture aspect of it, where it said, Part A says if you're something to the effect of if you're participating in a task force program, nothing from the bill prohibits you from participating in a task force program. And then Part B said that you cannot get any federal or obtain any federal money. You can't accept any federal money, I think is the way it's put. So if you're participating in a task force program, can you receive forfeited assets? I'm not quite sure if it's all or nothing. So, and I had that question. So, and I think at that, I've said my piece and appreciate the work of the committee and understand that compromises have to take place. But I don't even know why this bill came up with respect to Vermont, because I'm just not aware of any documented activity out there where we've been abusing it any more than we do traffic tickets with a significant amount of money that goes into the general fund. It's another money raising scheme, if you will. So thank you.
Yeah, Ben has it. I think Ben would like to say something.
Yeah, to that point about, if law enforcement was involved with a federal task force, there would be no penalty to accept money through that. It would just be if there was a violation of letting the federal government adopt a case for an amount that would be under $5,000. So federal task forces would be unaffected, and any money that would be derived from those cases.
Thank you, Ben.
Can I ask a question?
Yep.
So I guess my question is to Sheriff Marcoux and Tucker. That the comment you made was that anything that takes away the law enforcement's ability to deal with this crisis we should not do anything that would take away the ability to deal with this. My question is, does this bill in any small way take away that ability? And would it be better for us to not do anything with this bill and come back and look at the, or some people will come back and look at the questions that you posed? That's-
In my opinion, there's a lot that we don't know about. If this bill goes through, we don't know how it's going to work out, and we may need to come back to address unintended consequences. So my proposal, or my thought was that why not take the extra time to look into some of these questions about, how much the money, the extra cases that would bring to the courts, if indeed this would impact our ability to work as we have towards the drug crisis. This seems to be, I myself, if I was leading this, I have some questions that I put forth to you that I would look into, and it may be that this is a warranted. I don't think it is, but I don't know exactly, the abuses that may have taken place in Vermont. I don't know that. I don't know that anybody does. So it just seems that to take some extra time to look into that.
Thank you.
Thank you, Senator White.
Well, I guess it's that time where we have to make a decision one way or the other on the bill. No. I'm
Posed that question to Tucker as well, I thought.
Yeah, mainly to Roger, but I don't know if Tucker had any response to that or not.
Yeah, so as this is drafted in 3.1, it would require cases that were otherwise eligible for federal adoption below $5,000 and above $2,500, because that's the floor, to go through the state system. And so that's just a new carve out to say you can't use the federal system for that. And if I recall correctly, we heard testimony that there are about 7 cases a year of federal adoption with an average value of $4,000, if I'm recalling correctly. And so that's not all of the half a dozen, but most of them that would be required to go through this system. What is a little different in this proposed state system is that it does require a conviction or a cooperating witness or someone to abandon the property or flee the jurisdiction. And that is one of the limitations in this state system that rose to a level of concern for the state police, because there are circumstances in which they do make a seizure. They can prove that the seizure is essentially drug proceeds, but they do not want to pursue a criminal case against the person they seize it from. And that person may not be cooperative as a cooperating witness. And so that was kind of one of the scenarios that we were concerned about from the beginning. And for this class, it's a relatively small class, but for this class of seizures from $2,500 to $5,000 that would have to go through the state system, we wouldn't be able to pursue forfeiture if it fell outside of the conviction, cooperating witness, abandonment, or fleeing the jurisdiction requirements. So that was kind of one persistent concern with the state system.
Thank you.
Well, I guess I would ask is, would the Defender General, the state police, the Sheriff's Association, the State Attorneys Association, and we don't have the courts here, be willing to take a look at some of the questions that were asked by Sheriff Marcoux, to take a good hard look at what should be done and perhaps make recommendations to us next year, for those that may be here next year. take a hard look at this and not do something that might create. I hate to hear that we're going to have to test run this maybe and then find ourselves with unintended consequences, either because of limitation or because of some other. I'm wondering if that were to be replace all the language here with some type of report.
The sheriffs would participate, Senator Sears.
Thank you.
And of course, we do anything to help along the way. And I defer to the committee on whether that's needed.
The same would be true for the Department of State's attorneys. If the legislature would like some stakeholders to study this issue, we'll obviously do our best to assist.
I think it's probably the best thing at this late hour. If Ben, I hate to put another one on you, but if you could work on a not a report by you, but recommended legislation from the stakeholders that would replace this version of, or would actually replace the House version of the bill. Unless the committee wants to move forward with this version 3.1, and I'm willing to change the distribution amounts.
With apologies to Ben, I'm gonna say I'm not interested in moving forward.
With the what?
So ditto for me.
With apologies to Ben, I'm going to say I'm not interested in moving forward with this version, with this
Okay.
bill.
I'll tell you what,
Ditto for me.
I don't know how Ben got all these different bills, but
I
God,
know. I know.
like,
Yeah.
It's freshman hazing.
It's his own version of civil forfeiture.
maybe we could meet Friday morning at 9 o'clock to hammer out this final version.
Yes.
Can you do that?
Ben has a question.
Yeah, so Senator Sears, are you thinking of like a working group of these stakeholders that would then come up with some proposed legislation?
Yes.
Let's say by, I don't know, December or something like that? Or-
Yeah, they could report to, hate to keep throwing stuff onto justice oversight, but it's probably the appropriate place on suggested legislation.
That they would
I mean,
submit, that they would submit the proposed legislation to justice oversight?
Oh.
Or,
Are you thinking that Ben should somebody should come out of that with proposed legislation, or is that what you're looking for, Senator Sears?
I think that's what Roger was suggesting.
Okay.
Also information on, how many forfeitures there are in the state, what potential, what is, I mean, I think I start with the question is, why don't we do more state forfeitures? And the answer is, I don't know. But I think we should know before we change the law. Why aren't we using the current system? And I think that's part of the discussion. And then how could we improve the current system and still, anyone who's, we can put them all in there and see what they can come up with.
Senator Sears, can I make a suggestion?
Sure.
That instead of coming up with needed legislation, they should decide whether there is a need for legislation, and then if so, come up with it, because I don't think that we ever want to send somebody off to study with a foregone conclusion that of what they're gonna find.
Yeah, that's a good idea. It's if it's proposed. Well, the first thing is what are the problems with the current system? We've heard that, a lot of testimony about that. But how can we improve the current system? What about the incentives between the 80-20 of the federal and the 45-55 in Vermont. Is that, no, that's one of the questions, obviously, that several members of the committee were concerned about, as well as the Defender General.
Senator Sears, I think I can draft something up so that the committee could have it discussed Friday morning.
List of questions, Sheriff Marcoux included, should be part of that before I try to answer those questions.
I'll add those to the list as well.
All right. Why don't we schedule for 9 a.m. on Friday?
9 to 9:30,
What?
9 to 9:30 or 10, what, how much time?
9:30 to 9:45. Should be plenty of time.
9 o'clock.
9 to, I did, what did I just say? Did I,
Said 9 o'clock was the first thing you said.
yeah, 9 to 9:45. Should be plenty of time. Okay,
Peggy, are you?
anything
gonna have
else?
Joe bring up the Dan Richardson's,
Yep, I
so that we
did.
can get it on the calendar. Okay,
Yeah, all right.
okay.
Are we?
Jeanette,
Yeah.
will we do that Friday, Jeanette?
Well, it'll go on the calendar tomorrow, but it's supposed to be on the calendar for a certain number of days first. So I think we should check with Secretary Bloomer, because since we will be here next week, it's probably better to let it sit there for a couple days like it's supposed to.
Okay.
I think it's 5 days, but I don't know if weekends count.
Yeah, but and if it is 5 days and it's not weekends, that would be next Friday, and we can always suspend rules to take it up before the date if we need to.
Should I go offline, Senator Sears?